supporting documents.
And as for the merits issues, the respondent would like to proceed first, given that the respondent has to make out its case as to why they are exempted from liability under Article 79 of the CISG.
Madam Arbitrator, we are in agreement on these points.
But wouldn't it be your case that I understand the claimant's case is that the 2016 SIC rules apply?
Mr. Arbitrator, while indeed claimant is advancing the position that the 2016 rules apply, we believe that our arguments on the first issue are based on the negotiations and the procedural history which is already clear on the record. And as such, either party is in as good a position as the other to kick things off. However, on the second procedural issue, that concerns respondent's disclosure request, and as such it is more economical, or rather more efficient for respondent to present his positive case, which claimant can then respond to.
Would parties be open to having the claimant first make out its claim on make out its arguments on which set of SIAC rules apply, and then we can have the respondent as the one bringing the application for disclosure to then start producing documents subsequently?
Madam Arbitrator, our preference is for respondent to first submit on both issues, but
preference, but would you be open to it?
we are open to it.
Would the respondents be open to it?
Yes.
However, if I may have just a minute to discuss with my co-counsel on the, or rather discuss with Ms. Tham on the optimal time allocation. Thank you.
So, Mr. Paul and I have agreed on the speaking order. So, Mr. Paul will speak for 7 minutes on the first procedural issue on which SIC rules apply. And I'll be speaking next, addressing that issue, followed by the issue on disclosure, explaining the respondent's reasons for ordering disclosure. And after that, Mr. Kaur will be speaking on the second procedural issue. And after that, I'll be giving my rebuttals, and Mr. Kaur will be giving his rebuttals.
And so just to clarify, just to add on, the time allocation will be 7 minutes first for the claimant to address the first issue, followed by 14 minutes for respondent to address both issues, 7 minutes again for claimant to address the second procedural issues, and then 1 minute of rebuttal and surrender. And if
That sounds very complicated. I suppose you would want the full 14 minutes regardless of how you allocate it between the first and second component, actually.
yes, Mr. Arbitrator, however, if this tribunal prefers for claimant for the speaking order to be a bit more tailored in respect of the first and second issues,
Okay.
we're happy to have that order. And unless members of the tribunal have any further clarifications, we're happy to begin on that, in that order. Madam Presiding Arbitrator, members of the tribunal, good afternoon. I am Samuel Kaur, counsel for the claimant. I make one submission on the first procedural issue, namely that the SIC Rules 2016 govern these proceedings. In 2021, claimant contracted to sell its orchids to the now defunct Botanical Gardens. Their specifically negotiated arbitration clause was intended to apply the 2016 SIC rules and to deem mediation as the commencement date of arbitration. That clause was reviewed and approved by BG's board, which respondent's director sat on. When respondent took over the agreement following BG's insolvency, it amended other terms but was content to leave Article 15 intact. Our case is fundamentally the respondent cannot ignore what was agreed. The 2016 rules govern these proceedings, as first, Article 15 specifically applies those rules, and second, they were enforced when claimant requested mediation in December 2024, which Article 15 deems as the commencement date of arbitration. If if members of the tribunal will follow me to page 13 of the record, which is the sales agreement, the fourth line of Article 15, the arbitration clause, applies, quote, the current SIAC rules, replacing the model clause wording for the time being in force with a static reference to the rules current at the time of contracting. And this is confirmed by the negotiating history at page 21 of the record, which is an email from Botanic Gardens legal counsel to claimant. After claimant had first proposed the SIAC rules, BG's legal counsel confirmed at line 4 of the first paragraph that the current
which
version.
Page is this again?
This is at page 21,
Okay.
then presiding arbitrator.
Okay.
BG's legal counsel confirmed that, quote, the current version of the arbitration, the fourth line of the first paragraph. BG's legal counsel confirmed that the current version of the arbitration rules is acceptable to us, and this was after claimant had first sent the SIAC rules to them, and therefore current in Article 15 was intended to refer to the current version reviewed and approved in negotiations, which are the 2016 rules.
The line does state provided that we can include a modified version of the AMA protocol. So wasn't this conditional or subjective?
Mr. Arbitrator, that is a fair reading. However, we see in PO2 at page 56, paragraph 7, that indeed, following this correspondence, claimant had accepted the modified clause as Botanical Gardens suggested it, which meant...
So can I clarify your response is that it may have been a condition and that condition was satisfied because they did agree on a modified version? Is that your answer?
Mr. Arbitrator, I do not have a prepared position on whether it was a condition, but rather the facts show that there was no subsequent discussion. The parties did agree on what BG had suggested. And
Sorry, okay. The way I'm reading it is that Ms. Gorby was saying, if we can agree on a modified version of the AMA protocol, we will accept the current version of the SIAC rules. So my question to you is just, did they agree on a modified version of the AMA protocol?
yes, Mr. Arbitrator, they agreed on a modified version of the AMA protocol, which would start first with mediation.
Right, okay. I
But
think
even looking at page 21, at the heart of it, and correct me if I'm wrong, it seems that the dispute between yourself and your learned friend is on the interpretation of the word current, whether meaning then enforced at the time of the agreement or enforced at the time of dispute, right? When I read this, it could be read the way that you are suggesting, or it could also mean what respondent is saying, right? Current at the material type enforced agreement. So why should we, on the basis of this exhibit alone, confine ourselves to the reading that the claimant prefers?
Madam Arbitrator, I would make 2 points to answer your question. First, as Professor Schrenzer explains, references to instruments in the contract ordinarily mean the version published at the time of contracting. The rationale for this, as explained in the 2006 Swiss Filing and Packaging Plant case, is that parties cannot be taken to have agreed on a version of the rules of the version of an instrument that was not even in existence when they contracted. And therefore, our position is that a plain reading of current should be taken to mean
That
at
would
that
be
time.
true in principle, except that 15 was borrowed from the SIAC model clause. And in the language of the SIAC model clause, it was very clear in its original form that current meant didn't mean what you said. It means what the respondent says, that it is at the time at the point of dispute whatever is currently enforced would apply. So why shouldn't I take that reading? Should I take the intention of the drafters of the SIAC's meaning, or should I take the intention of parties at the time when contracting, which is the relevant intention to take?
Madam Arbitrator, while the SIAC model clause refers to the rules for the time being enforced, the original parties to this contract, VJ and claimant, modified it and replaced it with the word current. And the reason they did so, as found in the negotiating history, was because they had specifically agreed after extensive negotiations that the SIAC rules were acceptable, and they therefore agreed on the version that was reviewed.
So you're saying the word current was inserted by parties, it didn't exist in the original SIAC model clause?
Yes, Madam Arbitrator.
And were there any discussions by parties around the meaning of the word at the time?
Madam Arbitrator, I noticed that my time has elapsed. If I may have an additional 1 minute. They did not discuss the word current. However, this was inserted by Ms. Gobley, Botanical Gardens legal counsel, after she had informed claimant that the current version of their rules is acceptable to us. And if we look at the background of these negotiations, the arbitration clause required specific board approval by Botanical Gardens because it was the first time a public entity of their sort had agreed to foreign arbitration, had agreed to foreign-seated arbitration. And therefore,
And if I find that at the end of the day parties' intentions were not clearly established, then on which side should I go?
if parties' intentions were not clearly established, then on a then reading the clause in of itself, it should be taken to refer to the 2016 SIAC rules which were existent at the time of contracting, and that is because that is in line with the ordinary interpretation of references to an instrument in contracts.
So
Madam-
if the parties' subjective intentions are not clearly established, the CISG says we should interpret terms in a certain way, not that we just look at whatever you say.
Yes, Mr. Arbitrator. However, a reasonable person in the party's position or in claimant's position, having been proffered the amended clause and having been told that the current version is acceptable to us, would have understood current to mean the version that claimant had first sent over to BG for review, which is the 2016 rules. Madam Arbitrator, if I may have 1 minute to wrap up my point. This meaning,
I'm afraid to be fair to the respondent, given that you've already had extra time, you should wrap up. I'll give you 1 sentence.
this meaning continues to apply to the present arbitration clause between claimant and respondent because respondent is an assignee of the contract under Article 9.3 PICC. They had agreed to take over the contract and the intention was for the meaning to be the same. Thank you.
Madam Presiding Arbitrator and members of the Tribunal, good afternoon. I am Tan Mei Xuan, counsel for the respondent. I will make 2 submissions. First, the SIAC Rules 2025 govern these proceedings. And second, this tribunal should order the claimant to disclose its third-party funding agreement and its litigation risk agreement with Shaw. Turning to the
Sorry,
issue.
can I clarify, the only reason, the consequence of different set of the SIAC rules applying is the only effect of that is whether the third party funding agreement disclosure obligations apply, provisions exist in the rules. Is that the only difference?
Yes, but regardless of the differences, it's our argument that disclosure should be ordered regardless of what rules apply. So turning to the first issue on which of the SIAC rules apply. In 2022, the claimant and respondent signed the sales agreement. A disagreement then arose regarding the delivery of orchids in 2024. The the claimant then filed a notice of arbitration on 31st July 2025. The SIAC determined that the arbitration commenced on this date, and on this date, the 2025 rules were in force. It therefore came as a surprise that the claimant claims that the 2016 rules apply to this arbitration. And this is wrong. The 2025 rules in fact govern these proceedings for two reasons. First, properly interpreted, Article 15 applies the rules existing at the prevailing time when arbitration commenced. And second,
What do you say was the effect when the model clause was amended such that the words "for the time being enforced" was struck out and the word "current" inserted? What was the intention of parties behind that amendment?
the parties to that original contract, the 21 contract, it's likely that Botanical Gardens intended for the 2016 rules to apply.
Okay.
But we argue that there's no substantive difference between the phrase "at the time being enforced" and "current," because both mean the prevailing time, both refer to the rules existing at
But
the
if
prevailing
that
time.
was their intention at the time of contracting, that they wanted that specific version of the rules to apply, then is it open to you to now argue that something that's clearly contrary to that specified intention should instead be applied?
Yes, it's open to us to argue that
Right.
because Botanical Gardens is not a party to the 2022 contract. This is a contract between the claimant and the respondent.
So it has to be freshly construed.
Yes, exactly. So the intentions of Botanical Gardens do not bind the respondent because the previous contract was terminated. And members of the tribunal, if you can flip to page 10 of the record, in the preamble, it clearly states that the previous contract was terminated. So how can the intentions of a party who's not a party to this contract be used to interpret the intentions of the respondent? And in fact,
Sorry, I believe the point was made by Mr. Kaur that the respondent represented that it was taking over all obligations of the Botanical Garden. So wouldn't that mean they are taking over the obligations as they were agreed upon initially? Therefore meaning that they agreed upon, they were taking over the obligation to arbitrate under the 2016 CFA rules.
when the respondent said that they were willing to take over the rights and obligations, what they mean is they are taking over the business. This is not necessarily a consent to being assigned a contract.
How does taking over the obligations means taking over the business?
They're taking on the risk of the business, right?
Yeah.
When they take over the business.
Yeah.
And unless they told you, presumably they intended to take over the risk of the business as is. So what was it in anything that they say to you that signaled to you an intention to agree to a different interpretation of those words?
Even if it intended to take over the 2021 contract, it does not matter as the contract is no longer in force.
Let me try and explain our difficulty to you, right? In the first contract, the 2021 contract, there was a clearly agreed meaning. And you have also accepted that that meaning confined the words to the 2016 version. Another party comes over to you and essentially says, I'm going to step into the shoes of the person who previously was in a relationship with you. You say, okay. You didn't say we needed to renegotiate the terms, you didn't say we need to change the risk allocation, you didn't say anything, you said, okay. Would it be more reasonable for the claimant to assume that you had agreed to the terms as it was originally intended, or would it be more reasonable for them to assume that you had agreed to the terms but now with an amended meaning? You're suggesting the latter, but that doesn't seem reasonable to us. So if you think it's reasonable, what does that mean?
Because Madam Arbitrator, if we go with the first variant, it means that the respondent has agreed to being assigned all the rights and obligations of Botanical Gardens. But even if the respondent consented to this, the claimant and Botanical Gardens did not consent to this. And And under the PICC, assignment has all parties.
Is there anything in the record that talks to us about how the contract came to be taken over by the claimants? Would
Yes.
any of that be useful?
Yes, there is. So, if I may flip the tribunal to Exhibit C2, this is an email by the respondent. This is on page 9 of the record.
Page 9, okay. Okay.
So, in the middle of the page, it states that the respondent has agreed to take ownership of Botanical Gardens, including its commitments and liabilities.
Okay.
But nowhere in this record stated that the respondent has agreed to be assigned the 2021 contract.
What do you interpret that phrase to?
To be
That
taking
phrase you
over.
just read? Yeah.
It means taking over the business, their customers, their
Which means that
suppliers.
anything that they could previously be sued for, the predecessor to be sued for, they now can be sued for as well. Do you understand it that way?
Yes.
So does that not support the interpretation? And assuming that we're not with you, is there any other argument that you will make in support?
Yes, there is. So even if members of the tribunal are not with me on this point, the 2022 contract still applies the 2025 SIAC rules because the time where arbitration commenced was when the claimant filed the notice of arbitration on 31st July 2025. And the filing of a notice of arbitration marks the start of arbitration proceedings. And this rule is clear.
Sorry, did you say this is an even if argument?
It's an alternative argument.
It can't be an alternative, right? Because we find that they had agreed on the 2016 rules and they said we will arbitrate under the 2016 rules. Then your claim fails. As in your argument,
Your argument for disclosure, or
That-
the argument for which version?
because what you're saying is that because if parties agreed that the 2016 rules will apply always, then you can't say even if you don't follow that argument. Sorry, I thought I will have to accept that they had agreed to the arbitration rules that will be in effect at the time of commencement. Right? We will have to accept that interpretation for you to go on to argue that the 2025 rules apply. So it can't be it's not an even if argument, right?
Yes, apologies, tribunal, members of the tribunal, I may have misspoke. But this is our second argument that the time of arbitration only started when the claimant filed their notice of arbitration. And this is in line with regardless of what rules apply, regardless of whether the 2016 or 2025 rules apply. But if I may move on to my second argument, on the issue of disclosure, regardless of what rules apply, the tribunal should accept the respondent's request for disclosure. So the claimant is in a very poor financial situation where they are projected to be insolvent by June 2026. And it accepted that it cannot continue the proceedings without the funding of ATJ and LitSure to remove cost risks associated with the dispute. In light of this, the tribunal should order the claimant to disclose their agreements for two reasons. First, the respondent needs to know whether to apply for security for costs. And second, is for the respondent's defense against the claimant's claim for reimbursements of their funding costs. So under the 2025 rules,
So what's the second reason?
so the respondent's defense against the claimant's claim for reimbursements of the claimant's funding costs should the claimant
Defense against?
the claimant's
Defense.
potential reimbursements of their own funding costs. Now, I'll explain this later in my submissions, Mr. Arbitrator. So the tribunal has the power to order disclosure under Rule 38.4 of the 2025 SIAC rules. Now, my first reason as to
So
why
can you quickly explain to us if we find that the 2016 rules apply, then where's the source of our power?
under the 2016 rules, the power comes from Article 27F, where the tribunal can order disclosure of documents that are relevant and material to the case. So under both rules, there is a power for the tribunal to order disclosure. So my first reason that the respondent needs to know whether to apply positively for costs. So there's a high possibility that the claimant
27F says relevant to the case and material to its outcome,
Mhm.
which I interpreted as being material to how we decide on the merits. Is
Yes.
that not the interpretation?
This is one interpretation, but beyond the plain wording of Article 27F, procedural relevance and materiality is also considered by tribunals when they are deciding whether to order disclosure or not. So this can be seen in the SIAC case of Spears and McMytrade, where the tribunal also considered reasons such as whether there would be any potential conflicts of interest between the parties and the tribunal. So this indicates that a tribunal would also consider procedural relevance and materiality.
I'm actually struggling with the very first statement you made, which
Mhm.
is that you need these documents in order to decide whether or not to apply security for costs. If you are already of the view that the claimants are in serious financial difficulty and are unlikely to be able to make good on any cost orders against them, it's really open to you to bring that security for costs application. It seems to me that what you are, do I dare use the word fishing for, is more evidence to buttress your security for costs application, but it's not for us to aid you in that respect.
Yes, Madam Arbitrator, there's a scenario where the respondent will not apply for security for costs. That is, if Bitsure has agreed to cover 100% of the claimant's adverse cost order.
Why not just bring the security for cost application? You can show that they are impecunious, and it is then open to the claimant at the time, if it so wishes, to rebut or to argue against the application by showing whatever parts of the agreement that would show that they have sufficient funds. It seems like we're jumping the gun a little bit here. You know, we're trying to save you the cost of an application by helping you to fast forward the outcome. That's not correct for us to do.
So related to that, my question is, your submission was that we should order disclosure so that you can decide if you want to take certain litigation steps. But the tribunal only orders document production to help it decide disputes that are before it, not to help one party decide how it wants to conduct its litigation.
Okay, I'll address Madam Arbitrator's questions first before Ms. Arbitrator's. So on your question whether this is a fishing expedition, it's actually not a fishing expedition because what we are doing now is
Sorry, that was my question. My question was, is it open to you to, would it be possible for you to bring the security of a cost application and then at the point of time make the case that they have no money for this arbitration and leave it to them to produce whatever bits they want to defend it? If they choose not to produce at that time, naturally you would win your application if you can show that they have no funds. Is it open to you to do that?
members of the tribunal, I note that my time is
Please answer the question.
Yes, so you asked us if it is possible. It is possible, but for reasons of expediency, this is one of the principles of the SIAC rules. We would prefer to know whether it is necessary for us to
But expediency has to be balanced against fairness, right?
Yes.
It is unusual to order the disclosure of those arguments. It's not fatally prejudicial to you for them not to be ordered. So in the circumstances, which way should it fall?
Ordering disclosure would be fair to the respondent as well as the claimant, because it's only fair if the respondent knows that any potential cost orders can be met by a third party, because this is in light of the claimant's impecuniosity as well as ATJ's reputation as a well-funded. So they may not cover all the claimant's potential adverse costs. They may even withdraw funding mid-proceedings, and we'll only know if this is the case if we know the terms of the agreements. And it's only fair because the claimant is only disclosing the agreements to us, and we are bound by confidentiality. So there's nothing in this documents that reveal anything about their strategy.
In the interest of time, would you like to take my fellow tribunal members' questions and then
Yes.
turn the time back to claimants?
May Mr. Arbitrator repeat your question, please?
Yeah, so my question is, basically your submission was, you should disclose certain documents so I can decide if I want to do A or not. But it doesn't seem to me that that's in line with how we make disclosure obligations, which is usually more of you make an application and then I have to decide a certain matter. And then you say you disclose this document because it will help me to decide that particular disagreement. Yeah, so do you have any authority or something to suggest that I can document disclosure to aid one party in making certain strategic decisions about the applications that it wants to make or that it does not want to make?
Yes, so Mr. Arbitrator, you said that it may not be in line with how tribunals make decisions, but there is authority that shows that the tribunal has ordered disclosure of documents before out of the respondent's concern that a third party may not cover adverse cause and out of their consideration to apply for a cause. So this can be found in two exit cases. The first being Muhammad Kat and Turkmenistan, heard in 2021, and another exit case in 2022 of Amir Tahiri, where both tribunals have ordered disclosure of the claimant's third-party documents.
And this was even before any security for cause application has been made?
Yes.
I see.
What was the reason for the disclosure?
So for the first case on Muhammad Kat and Turkmenistan, the tribunal ordered the claimant to disclose the external funding documents because of the respondent's intention to seek security for cause and the concern that a third-party funder may not satisfy an adverse award. So the facts of the reasoning can be equally applied to our case, but there is a strong possibility that the claimant cannot fund an adverse award. So members of the tribunals, if there are no other questions, I conclude my submission.
I thought you said you were going to explain something about funded costs or something.
Yes, that would be our second reason as to why.
Can you say that very quickly?
Yes, of course. So disclosure is needed to know. Disclosure is needed for the respondent to know how much they have to pay the claimant in case the respondent loses, because the claimant has reserved their rights to claim for any costs that happen during the period of the proceedings, and these costs may be high, given that ATJ is an aggressive player in terms of financing agreements. And without knowing the agreement, the respondent wouldn't know how much cost they have to prepare to pay a funded claimant. I've concluded the second reason.
Wait, sorry, I understand that part of the submission. You're saying the respondent wouldn't know how much he has to pay.
The claimant should the respondent lose.
But how does how much the claimant is funded affect that?
Because the claimant has reserved their rights to claim for additional funding costs. The claimant is funded by ATJ. So knowing the contents of the ATJ document would inform the respondent as to how much the claimant is being funded. And the respondent can take measures to prepare to pay this amount of costs.
I see. But wouldn't that be more relevant when the question of costs? No, I think it's alright. Thank you.
May I begin? Thank you. Members of the tribunal, Madam Presiding Arbitrator, I now turn to my second submission that this tribunal should reject respondents' requests for disclosure of claimant's third-party funding agreement with ATJ and our litigation risk insurance agreement with Litra. And I make two arguments. First, the agreements are not relevant and material to the issues that respondent seeks disclosure for. And second, in the alternative, they should be excluded from disclosure for reasons of fairness. First, under the Rule 27F of the 2016 rules, as my learned friend had earlier explained, this tribunal is only empowered to order disclosure of documents which are relevant to the case and material to its outcome. And this means whether a document will likely affect the final determination of issues in these proceedings. Even if the 2025 rules apply, as my learned friend as the respondent contends, this tribunal should
Do you
still
agree with the
consider.
categorization that the test of relevance and materiality could also apply to, in their words, procedural matters?
Mr. Arbitrator, it can apply to procedural matters like SFC applications, from my understanding of the cases. However, we will still submit that it cannot apply to issues such as a party's strategic considerations. If anything, in respect of the SFC application,
No, that's not their argument, right? Their argument is they can get the disclosure application, the documents to be disclosed will affect the outcome of the SFC application.
yes indeed, Mr. Arbitrator, the relevance and materiality test applied to the SFC application requires that the documents will materially affect the outcome, the tribunal's determination of the SFC application, and we say that test is not made out. To briefly turn to
The respondent has cited two cases in support of its application for disclosure. Do you agree with the outcome in those cases, and do you think that those cases are analogous to the current situation? Feel free to take the question in whichever order you prefer.
no, Madam Arbitrator, the facts of Madam Presiding Arbitrator, the facts of those cases are very different from the present case. That is because in respect of respondent's potential SFC application, claimant has already disclosed our financial situation, the fact that ActJ does not cover adverse costs, and the fact that we rely on LitSure to cover adverse costs. And therefore, in respect of this reason for seeking disclosure, the ActJ agreement in the first place is totally irrelevant, since we do not rely on it to meet adverse costs.
So you're
The-
saying
the-
you agree with the cases and how they were decided, but you're saying they don't apply here factually.
Yes, Mr. Arbitrator. If I may explain, in the case cited by my learned friend of Muhammad Kat, the tribunal there ordered disclosure of funding costs for a respondent's SFC application because the claimant there had a history of not paying adverse costs. But in contrast, we see that from PO2 that the insurance, the insurer LitSure has a very good market reputation, and therefore our case is that it should be taken to be reliable, and the case is therefore distinguishable from Muhammad Kat. Indeed, in the 2015 exit case of Eurogas and Slovak, the tribunal there declined to order SFC against a funded claimant, distinguishing the facts before it from cases where the claimant or the funder had a history of not paying adverse costs. And therefore, the agreements are not relevant and material to a potential SFC application. In respect of the other reason that respondent seeks disclosure
So
for,
how would it prejudice you if we order disclosure
Mr.
of the insurance agreement?
Mr. Arbitrator, that brings me to my second argument, which is that in any case, the agreements should be excluded from disclosure for reasons of fairness. This is because disclosure of both agreements will cause unfairness, as the agreement terms would indicate the funding amount and the funder's rate of return, or the insurance premium, as the case may be. And by analyzing these terms, by comparing them to market rates, respondent can make an educated guess about the evaluation of the merits by claimant and our funders, which will give respondent an unfair strategic advantage in preparing its case. This prejudice was recognized by the SIAC Tribunal in the 2018 partial award in Spears and Make My Case, recognizing that the funding terms would, quote, necessarily suggest how the claimant's counsel and the funder have assessed their chances of success. And therefore, our second argument is that this tribunal should exercise its power to exclude documents from disclosure, these agreements from disclosure, even if they are relevant and material, to uphold fairness in these proceedings. Members of the tribunal, if I may then quickly address claimant's second reason for seeking disclosure, which is that it needs the agreement's terms to prepare is to know how much it has to commit to a potential adverse cost award, or to prepare its defense against the claims we have reserved seeking reimbursement of those costs. We will point out
That's quite a mouthful. Could you explain what that means?
that means that well, Mr. Arbitrator, if respondent if claimant prevails in these arbitrations, our funders uplift, in other words, the portion of the award that is payable to them, can be claimed as adverse costs against the respondent, and the tribunal's power to do so comes from its power under the SIAC rules to order parties to pay another party's legal or other costs, which is interpreted in the 2020 SIAC case of Spears and Make My Trip to include funding costs. However, in members of the tribunal, if I could have an extra 30 seconds to wrap up this point. However, in the cases such as Spears and Make My Trip and the 2016 English High Court case of SR Oilfields, tribunals have considered multiple factors in deciding whether to exercise its discretion to order a losing party to pay the other side's funding costs. But the only relevant term would be the funder's rate of return, which is used to analyze the reasonableness of seeking funding. And here, that single term alone would already be known by the time claimant makes a claim for reimbursement. And therefore, the agreements are not relevant and material for that reason as well. The agreements should therefore not be, the disclosure should therefore be rejected. Thank you.
Members of the tribunal, I have 2 points to make in my rebuttals, one for each issue. On the issue on which of the SIAC rules apply, it's our submission that the 2021 sales agreement was terminated, and hence the intentions of Botanical Gardens are totally irrelevant in interpreting the contract.
Why do you have a rebuttal? Why do you need to make a rebuttal on which rules are applicable? Because after you went, there was no submission from the claimant on which rules are applicable. Was it? Did the claimant went first, then you went. After that, did the claimant say anything about which rules are applicable?
No, Ms. Arbitrator.
Right, so there's no need for a rebuttal on that point, right?
Yeah, I will keep my rebuttals to just the second issue.
Unless my co-arbitrators would be minded to hear. Right, I guess you can allocate the time as you wish.
So I'll proceed with my 2 points.
Yes.
On the first point,
Please go ahead.
Go ahead.
I'll quickly wrap up the first issue. So only the claimant and the respondent's intentions should be used to illustrate the 2022 contract. And on my second point, the issue on disclosure, claimant has argued that the literature has a good reputation, and hence.
Sorry, before that, the claimant said the main agreement they have already considered does not cover adverse costs.
Yes,
So do you accept that there's no reason for us to be ordering disclosure of the agreement
we don't accept that,
because of?
and that's because the claimant has reserved their rights to claim for their third-party funding costs, and only the agreement with ATJ can review them.
I see. So, okay, but then your SFC argument does not apply, right? So you're just saying the main funding agreement, you only need to know that for the purpose of preparing how much cost you might need to pay in case costs are ordered against you.
And the SFC argument is relevant for the literature document.
I see.
So the claimant has argued that literature has a good reputation, but that does not guarantee that they will be covering 100% of the adverse costs. And the respondent will only know if we see the terms of the agreement, and that's why disclosure must be ordered. If members of the tribunal have no further questions, I conclude the rebuttals.
Thank you.
Yes, okay.
Members of the tribunal, I will make one point in rebuttal, or insert rebuttal, responding to my learned friend's second point. So here, even though the particular and detailed terms of the agreement could theoretically affect respondents, could technically affect the strength of the adverse cost coverage, the fact remains that respondent has sufficient information to make its SFC application. It knows that we are funded by Litera and that Litera is covering adverse costs. It knows that ordinarily there might be circumstances affecting the security of those such coverage. It can raise those arguments, and it does not need disclosure to bring its full arguments on the merits of an SFC application, and for this tribunal to decide the same. Thank you.
But let's just say if they bring the SFC application, then it transpires, then you produce the agreement, and then they lose the SFC application. Isn't that a waste of time and cost?
Mr. Arbitrator, I have not consulted with my client on this, but I will point out that it is not necessarily the case that if they brought an SFC application, we would voluntarily disclose the Litera agreement. And that is because past tribunals have often, such as in the 2015 Exit Tribunal case of Eurogas and Slovak I raised earlier, have often considered the reliability of the insurer based on their market reputation to be sufficient and did not require disclosure of the specific terms. And in any case, that would be our strategic choice, not something which
It would
they are
be open
entitled
to the
to.
tribunal, I presume you're gonna say, to order the security for cost and then you take it as a game, that kind of thing.
Yes, Madam Presiding Officer. Thank you.
I think we should take a 3-minute reality timeout. Yes, I will. So my dear friends, the jurisdiction part is done. How do you think the show is going? How would you describe the run? So basic things to think about, right? One, is this show going in your favor right now on balance, listening to the two of them? What's your view?
I agree it's going in claimant's position.
By a big margin?
I think by a considerable margin.
Do you think we have, the tribunal has a certain temperament? Was our temperament what you originally expected it to be?
I'll say yes. I think it was what we expected.
So no adjustments to make to however you want to run the show. Alright. My dear counsel for the respondent, how do you read the room right now? How's it going for your team?
I think for both sides, there are probably questions, some unanswered questions and unaddressed answers. I feel like that's what I'm feeling.
Okay, and is it going in your favor at this point? Is it fairly evenly balanced, you think, or it's clearly not going the way you'd want it to go?
Maybe not as ideal as we would like it to be.
Is the tribunal what we had expected it to be? Where our concerns were, what we seem to be interested in?
Yeah, sorry.
So also no adjustments to make. Let's go. I tried. Alright, let's move on.
Madam Presiding Officer, members of the tribunal, good afternoon. I am Nicholas Chin, full counsel for the respondent, and I'll be addressing the issues of the exemption of liability as well as the calculation of damages. And I'll be speaking for 14 minutes and will reserve 1 minute for my rebuttals. Our client was fully committed to fulfilling its contractual obligations in the sales agreement with claimant. It had invested millions into building specialized greenhouses just to house the vanilla orchids which they will receive from claimant. However, they were caught off guard by Equatoriania's change in attitude to a more restrictive granting of import permits, which culminated eventually into a suspension of the issuing of permits, pending further ministerial guidance on 14 February 2024. Thus, respondent at that point could no longer obtain the required import permit. And additionally, claimant's subsequent sale to Herbal Cosmetics was not only concluded before it avoided the agreement, but also below the prevailing market price at the time. We therefore make two submissions today. Firstly, that the change in attitude satisfies the requirements of both the force majeure clause, which can be found at page 13 of the record, as well as Article 79 of the CISG. And secondly, that claimant has not met the requirements for Article 75 of the CISG to apply, and even if it had, any recovery would be limited to 2,700 orchids. So on our first submission on the exemption of liability, we have three arguments to make. Firstly, the change in the Equatorian government's attitude that resulted in respondents' inability to obtain an import permit was beyond respondents' control, and this constitutes an impediment under Article 79, as the change in attitude was an objective circumstance which prevented respondent from performing its contractual obligation to obtain the necessary permit. And this finds support in the commentaries on the CISG by Professor Kroll and Professor Schwenzer. And it is also considered a government measure as stated in the
So
fourth
you
measure.
said you had three arguments to make on exemptions.
Yes, Mr. Archie.
So you stated, so it's Article 79 of the CISG. Is that right?
To clarify, we are addressing the arguments that we're making are addressing both Article 79 as well as exemption under Article 79 as well as exemption under the force majeure clause.
So you say they have three common elements that need to be satisfied.
Yes,
And-
Mr.
So I have a question that's, I guess it comes before that, which is, does the force majeure clause displace the default CISG defense? Because it seems that, as in my reading would be that parties had negotiated for certain specific conditions that have to be satisfied if you want to raise these kind of force majeure defenses.
The force majeure clause does not displace the operation of Article 79, and both can operate simultaneously. And past tribunals in previous cases involving the CISG, such as the 1997 German iron molybdenum case, in that case, the court decided to deal with both, to analyze both the exemption under Article 79 as well as the force majeure clause. So
And they held that both can apply at the same time.
the court applied both at the same time in its analysis. So, and the reason for this is because the contract does not expressly displace Article 79.
Can you point us to the force majeure clause, please?
Yes, certainly, Madam Presiding Arbitrator. That's at page 13. You'll see clause 12.1. And as the tribunal may note, the requirements here overlap largely with Article 79.
Do they differ in any material?
They differ in relation to just namely two areas. One being that the event must have been foreseeable at the time of contracting, which this force majeure clause does not contain, as well as the notice requirement, where here it is parties are required to notify the other within 5 days of becoming aware of the event, while under Article 79 they may only have to do so within reasonable time. So, coming back to the first point, that the impediment was beyond control, it is submitted that under both Article 79 and the force majeure clause, such an event
So
Yeah.
I just want to be sure. So for the force majeure clause, what you're basically claiming is that it's your client is not liable because of an event beyond its reasonable control.
yes, under the category of government measures, Madam Presiding.
Okay, so the government measures were not within their reasonable control.
Yes.
Why?
This is because the change in attitude was something that parties could not only have foreseen in time, but they had no influence over the government's decision.
Then every law would be an act of force majeure. Every change in law would become an act of force majeure, right? If there is sufficient signaling in advance and there were actions that you could take to avert, mitigate, reduce the impact of the change of law, would it still be considered a act beyond reasonable control?
So every event that was not foreseeable would constitute such a measure. And as Madam Presiding Arbitrator rightly
I
pointed
thought
out,
you seem to be mixing up the requirements. Because you said, first there's control and then there's foreseeability. And then you said foreseeability does not apply to the force majeure clause.
to clarify, Mr. Arbitrator, not all events beyond control would fall under the force majeure excuse. And what is required is that it, at least for the purposes of Article 79, it must have been foreseeable at the time, unforeseeable at the time of contracting. And what is common to both the force majeure clause and Article 79 is that there must have been no other steps that the
Sure, I
party
want to
can take.
concentrate on the force majeure clause, right? Let's
Yes.
look at 12 of 1. So, what does beyond reasonable control mean here? If I know that there's a law coming, clearly I cannot affect what Parliament does, right? But if I am able to take preemptive steps to reduce the burden that the new law would impose on me, is that within reasonable control?
In that case, it would be beyond, it would be considered within the party's reasonable control. Yes.
Okay.
Which
So was it known, was the impending change of law known to the respondent? Or did it come very sudden?
Well, the change in law could have been expected by the parties in September 2023. What they could not have foreseen was that there would be a change in the Equatorian government's attitude in the way that it issued permits and its permit issuing approach. This is because previously they had adopted a generous interpretation of the existing exceptions in granting such permits. And they only changed this attitude on the 8th of February when the minister announced that it would adopt a stricter approach. So this was, and this announcement came after the site's decision to effect on the 1st of February 2024. And so, if I could just address the tribunal on the steps which the respondent took in order to try to overcome the effects of this impediment. The respondent here had acted reasonably, as the moment an import permit requirement was imposed on the 1st of February, our client conducted an internal review, contacted the authorities, and on the 5th of February applied for an import permit. So the first sign of a change in attitude only came on the 8th of February, the minister's announcement. And thereafter, with the suspension of any import permits, the issuing of any import permits on the 14th, the respondent could not take any more steps beyond that point. And I know that my time is running short, and if I may address the tribunal now on the issues of the calculation.
One more question from me. It would seem to me that any loss that was suffered by your client was really caused by its assumption that there would be a grace period in the implementation of any new measures. So, can it really be said here that your client had experienced an effect of force majeure? Or was it really simply the victim of its own assumptions?
We would say that the respondent had reasonable grounds for its beliefs that not only that conference XXA, which is what Madam Presiding Arbitrator is referring to, will not be invoked, but respondent also reasonably believed that the Equatorian government would have maintained its stance, given that historically, even in spite of considerable criticism from other site's member states, the Equatorian government did not change its attitude or its approach in issuing such permits. And as for Conference XXA, which is the resolution for such a...
What is the specific government measure that you're saying has caused an invocation of the force majeure clause? Is it the change of law, or is it the change in stance in the issuing of permits? Which is the act of force majeure law?
It is the latter, Madam Presiding Arbitrator.
So it is the change in the stance of
I-
issuing government permits.
Yes, Madam Presiding Arbitrator. So if I may turn now to,
Is that a measure?
it is the, it could be considered a measure because the government is taking a stricter approach in its issuing practices and taking a stricter interpretation of the existing exception for issuing such permits.
So when I read government measure, I thought you were going to say the measure was the refusal to grant a permit. I thought that is a measure, a change in attitude is
It's not a measure.
Yeah, it's not a measure. Right. As in, does it affect your case? I'm trying to understand, is there a reason why you have chosen to frame it as a change in attitude rather than the measure of refusing a permit for certain type of incomes?
Perhaps I did not make myself clear. The change in attitude is what culminated eventually into that suspension of issuing of permits on the 14th of February.
Right, so the measure is the non-issuance of permit.
Yes, which was a result of this change in attitude.
Which again could have been reasonably controlled if you had made sufficiently early preparations for the securing of the permits and the delivery of the goods.
I know that my time is running short, but to quickly address that point,
Yeah.
we say that there was respondent had acted reasonably in the circumstances and they could not have taken other actions to prevent or to avoid the impediment or the event.
But it sounds like if you could have gotten the permit just a month early, wouldn't it have solved your problem? After all, this contract was entered into in 2022, so you had more than 2 years to get the permit.
It is because there was no import permit required prior to the decision made by the sites committees on the 1st of February. So therefore there was no need for respondent to take any action until the import permit restriction arose. on the
When
1st
did the restriction arise, and when did the change in the government stance arise?
So to clarify, the import permit requirement was imposed on the 1st of February, and the government only announced its change of its attitude on the 8th of February. So between the 1st and the 8th, the respondent did what they reasonably could by contacting the authorities and for applying for the necessary permits. And so we submit that there is no further steps which respondent could have reasonably taken. And so if I may address the tribunal now on the point of damages, the claimant is trying to claim damages under a transaction that does not satisfy Article 75 of the CISG. And we have three arguments in this regard. The first is that the sale to Herbal Cosmetics
Of
was
these three, which do you think are the strongest?
it is the present point that I'm addressing the tribunal. Yes. So, firstly, the sale to Herbal Cosmetics was not a substitute for the parties' agreement, and we say this for two reasons. The first is that it was not carried out in order to replace the parties'
Sorry,
agreement.
where this is Article 75.
Article 75 of the CISG.
Where
Yes.
does it say there has to be a substitute? And which page of the rules booklet will I find this provision?
This can be found at page 36 of the rules booklet.
Right.
Yeah, page 36. It says that the party claiming damages may recover the difference between the contract price and the price in the substitute transaction. So the term substitute transaction here is the point that we're addressing now. And we say that the sale to Herbal Cosmetics was not such a substitute transaction. Because firstly, it was not carried out to replace the parties' original agreement, but rather it was a rearrangement of claimant's existing contractual arrangements with Herbal Cosmetics.
So as in, I read the meaning of a substitute transaction as referring to what is stated in the second and third line, which is that if the buyer has bought goods in replacement or the seller has resold the goods, that is a substitute transaction.
Yes, Mr. Arbitrator, you're right
Yes.
to read that.
So as long as the seller has resold the goods, then that is a substitute transaction. Right?
I know that my time is running short, but I'll just address this
Yes,
point.
please.
So, PAS, despite the reselling of goods, if this was done in the context of pre-existing contractual arrangements that the innocent party had with a third party, then that cannot constitute a substitute transaction. And this finds support in a case such as the Dowji Carrier case, where in that case the court did not constitute the transaction with the third party as a substitute transaction, because the contract had existed prior to the breach of contract and could not have been said to replace the agreement between the parties.
So for it to be, what you're saying is that for it to be a resale, there must be a contract after the date of the breach. Of the, what is the relevant calendar point before which there cannot be a pre-existing agreement?
Yes, it must take place after avoidance of the contract,
Right.
which the reason for this is that it gives the parties certainty as to and allows a tribunal to calculate damages in
Isn't damages calculation just a mathematical matter?
If I'm a party choosing between whether to continue with the contract and hope that the other side bears up or not, or to terminate and to try and dispose of the goods as best as I can, it would be, I think, very commercially impractical to first avoid and then look for reseller. I would at least want to have in my pocket a likely reseller before, a likely rebuyer or a subsequent buyer before I took steps to avoid it, right? So what the claimant was doing didn't seem to be entirely out of the commercial sphere of realities. If I had a pre-existing contract and subsequently I find that you cannot fulfill your part of the bargain and I divert goods to now fulfill this pre-existing contract, would that not be a reasonable act on the seller's part? Why can't it do that? So
We-
it's not just the rediversion that has to happen after avoidance, it's the very agreement that you say needs to be formed after the agreement. What authority do you have for saying that and why?
We would say that it would not be reasonable for party to do so for the simple reason that this contravenes the explicit wording of Article 75, which is that the sale must take place after avoidance of the contract.
Where does it say that?
It says in the second line, from
It
the
says
first line,
resold.
if the contract is avoided and if in a reasonable manner and within a reasonable time after avoidance, the seller has resold the goods. So the sale has to take place after avoidance of the contract. And you submit that in the hypothetical that you have given Madam Presiding Arbitrator, they would be in contravention of the explicit wording of this article. And if I may with no further assistance to this tribunal, that concludes my.
Don't see it. But okay, no
Thank you.
problem. You can always be of assistance.
Good evening, Madam Presiding Arbitrator, members of the tribunal. I will speak for 14 minutes and reserve 1 minute for my rebuttals. Respondent claims that a change in the government attitude has prevented it from performing its contractual obligations. It cites the suspension of the import permit issuing as something that has prevented it from accepting delivery of its goods. However, the named place of delivery in the contract is in capital city Mediterranean. Respondent cannot claim that its inability to obtain import permits for Equatoriana prevents it from accepting shipment of the orchids in a different country. In truth, respondent's reiteration to claimant on 27 February 2024 that it was impossible for it to fulfill its contract obligations was motivated by the fact that it made the business decision to divest of its spices line. This decision was motivated by its falling sales due to boycotts by NGOs because of the vanilla orchid. Forced to resell in a depressed market, claimants only recovered half the amount that it would have earned from respondent. We therefore make two submissions. First, that a change in attitude does not satisfy the requirements under either the force majeure clause or Article 79. And second, the claimant has satisfied the requirement to rely on Article 75 and can do so for 3,300 orchids. Beginning with the first submission, there are two arguments for why neither the force majeure clause nor Article 79 are satisfied. First, the change in attitude was a risk the respondent had contractually assumed that did not prevent it from accepting shipment of the orchids in Mediterranean. This argument addresses the forcibility, the element of being beyond control, and that its performance was not prevented by this alleged impediment that's common to both the force majeure clause and Article 79.
So where does it say that it must prevent that event must impede that the impediment must prevent the performance? Which words am I looking at?
Mr. Arbitrator, if you're referring to the force majeure clause at page 13 of the contract, it states that the party is not liable for failure or delay caused by events, and it's our position that the change in attitude was not something that could have caused the failure to perform the contract.
Is this a government measure?
Mr. Presiding Arbitrator, apologies, Mr. Arbitrator, while it is not a government measure within the meaning of the force majeure clause, because parties have specifically assumed the risk of the change in attitude. Therefore, it takes outside the scope of the force majeure clause and is not one of the government measures considered. This assumption of the change in attitude is seen from clause 5.1 of the sales agreement, which is at page 11 of the record. At page 11 of the record, clause 5.1 requires the buyer to obtain all import permits for the country of destination.
So aren't they
However-
saying, then since you've pointed this clause out, then aren't they, in response to what you said earlier, aren't they saying that they can't perform this part, Article 5.1a, and therefore they're excused from the whole contract?
No,
Isn't this
Mr.
contrary to your previous point?
No, Mr. Arbitrator, because the requirement to obtain the import permit does not affect its ability to accept delivery in Mediterranean.
Was it you who avoided the contract, or was it respondent who avoided the contract?
It was respondents who avoided the contract.
What was the act of avoidance?
The act of avoidance was on 27th of February 2024, where it notified claimant that it would not fulfill its contractual obligations.
Okay. And so, as of that date, you took the position that the contract had been avoided.
Yes, Madam Presiding Arbitrator, that was the date in which we avoided the contract subsequently.
So I thought in the notice of arbitration you said that it's 1st March that you terminate the contract.
Yeah, that was what I was avoiding. So that you or
Apologies
was it
for the
respondent
slip
who
up.
avoided?
Mr. Arbitrator, claimant avoided the contract in his email on 1st March 2023. However, we took reference to the declaration by respondent on 27th February 2024. I meant 2024 previously when I mentioned email.
Right. So, although, so you accept that it was your client who avoided the contract.
Yes, Madam Presiding Arbitrator.
But in the same breath, you're saying that there was no reason why respondent couldn't have taken delivery. Couldn't you have just delivered all 3,000 orchids to the point of delivery on the day that delivery was due?
Madam Presiding Arbitrator, we did not deliver the orchids on the date that delivery was due because respondent had already indicated clear intention to not accept delivery of the orchids. Therefore, we accepted it as its desire to repudiate the contract and avoided it. And this avoidance was not something that was not preventable for respondent because there was no requirement to obtain the import permit to take delivery in Mediterranean. Furthermore, this risk of non-performance was assumed by the respondent when it agreed to obtain all import permits, despite the fact that at the point of contracting, there was no requirement for a respondent to obtain the import permits.
Changing the topic slightly, the respondent took issue with the timing of the resale agreement. Do you have anything to say in response to that?
Yes, Madam President Arbitrator, even though our client resold the orchids before the official avoiding of the contract, that does not defeat our reliance on Article 75. This is because, under Article 75, it is a recognized exception to the plain words of the provision that as long as there is serious and final refusal to perform, and even if that occurs before the avoidance of the contract, that the innocent party can conduct a cover sale to resell the goods. And this is precisely what our client did.
What's your authority for saying that?
This authority comes from the case of Iron Molybdenum, which is the case respondent cited earlier, where the court accepted that if there was a serious and final refusal to perform, that the party need not have formally avoided the contract.
Is that the only case that has taken a decision? Has it been followed with any other decisions?
This is not the only case, Madam President Arbitrator. There's also the 2023 Cairo case, the diammonium phosphate case, where they also accepted that there was an exception, and this exception is recognized also by learned scholars such as Professor Schwenzer in a commentary at page 13705.5.
And what's the rationale for the exception?
This exception is grounded in the principle of good faith under the CISG, which is seen at Article 7. Under the principle of good faith, a party that has given its serious and final refusal to perform the contract cannot in good faith expect that it still has the option to perform it.
If, let's say, we find that we should stick to the explicit wording of the convention as applied under the relevant domestic law, would you be able to claim the same damages outside of Article 75?
Mr. Arbitrator, if you were to stick to the plain wordings of Article 75, you would then have to resort to Article 76 in order to claim damages. According to Article 76, damages would then be taken with regard to the market price at the time, which would then be the price of $1,100 per orchid.
Isn't that what you're claiming for?
However, not exactly, Mr. Arbitrator, because in our present case, we sold the orchids to Herbal Cosmetics at a discount of $100 for the sale price of 1,000 orchids. This means that the amount that we can claim from respondent will differ by $230,000, $27,000.
Okay.
In any event, it is our position that Article 75 does apply, and that the force majeure requirements and Article 79 requirements have not been made out.
Do you accept the respondent's position that both the force majeure clause and clause 75 apply at the same time?
Yes, we accept, Madam President Arbitrator,
Okay.
and it's a position that both do not apply. Given that we have established that the substitute sale was a cover sale within the definitions of Article 75,
I think I'm not sure if that's the case. Didn't respondent argue that this was not a substitute transaction because there was a pre-existing contract? The sale was conducted under a pre-existing contract, and he cited a case for that.
Mr. Arbitrator, we would disagree that just because this sale had relations to a pre-existing contract, that it was not a substitute agreement. This is because the test for determining what is a substitute agreement depends on whether the sale fulfills the same contractual objective as the original agreement. And the contractual objective in the present case was the sale of the orchids that were meant to flower in June and July 2024.
The test for a substitute transaction is a transaction that fulfills the objective of the
Original transaction.
That sounds. You see, but it's always a sale of goods contract. So you're saying that as long as it resells the goods, it's a substitute transaction.
Yes, that's our position, Mr. Arbitrator. And this is consistent with the plain words of Article 75, which merely requires the goods be resold.
So you're saying as long as it's the same goods,
Yes.
what if they change up the goods? Or does it matter if the goods are fungible?
The respondent was picking on the word after avoidance in section 75. So, in response to that, you had cited cases which suggest that there is a good faith exception to the word avoidance, provided that the other party had already clearly stated its intention not to perform. Correct?
Yes, ma'am, Mr. Arbitrator. With regards to this, there was a serious and final refusal to perform, which was on the 10th of February 2024. On the 10th of February 2024, and if I may point this tribunal to the record, page 16, paragraph 4.
Okay.
We see, and I quote, the respondent had told claimants that it will be impossible to obtain the import permit within the period required to meet the original delivery date. Even though it had stated that it was very doubtful that delivery could take place at all, we see from past cases that in the event that delivery is of the essence, but the breaching party does not provide any concrete alternative delivery date, that can be interpreted as a serious and final refusal to perform. And this is from the 1997 Ain Molibidman case. Therefore, it is our position that there was a serious and final refusal to perform, which allows our clients to rely on the exception to prior avoidance under Article 75.
Your opposite counsel has made arguments that the changes were beyond their reasonable control. Do you have a view on that?
Yes, Mr. Arbitrator. Our view is that the changes were not beyond their reasonable control because they had assumed the risk of such changes, and because they had assumed the risk of such changes occurring, they cannot now turn around and say that they did not assume or it was not within their control for these changes to occur.
In what way have they assumed this?
Well, Madam President Arbitrator, now my time has elapsed. If I may have 1 minute to conclude. They had assumed the risk because they agreed to obtain all import permits back when there was no import permit requirement. This meant that the clause to obtain all import permits was prospective in nature and intended to be forward-looking, where they agreed to obtain any import permit that would be required in the future under whatever law existed.
I think the reasonable interpretation is that the buyer will obtain all import permits that it is possible to actually acquire, rather than it being a guarantee that they will assume the risk of import permits. Because what the respondent is saying is that by law I cannot obtain the import permits. Like it's impossible for me to obtain the import permits. And you're saying that they also assume the risk, which seems to me to be reading quite a lot into this line. Is there anything else in the record that would support what you're saying?
Mr. Arbitrator, there is nothing in the record that supports what we are saying. However, we do have authority that supports the position that the agreement to assume the risk of a change in law to require a subsequent import permit is considered unconditional if there was no qualification to its obtaining of the import permit. In the present case, the words used are of
Can you re-say what you, can you repeat what you just said? An agreement to assume
the risk of changes in law.
Right, but there's no agreement to assume changes in law.
Maybe let's take a step back. As of the date when the contract was avoided, is it your position that it was still theoretically possible to obtain a permit, which is difficult or very unlikely, or do you accept that it was impossible to obtain a permit? Which one?
We accept that it was possible to obtain a permit.
So it's still possible to obtain a permit, just that it's very difficult to get one given the circumstances. That's where you're going, right?
If I may clarify, are you talking about the time of contracting?
At the time of the avoidance of the contract.
At the time of the avoidance of the contract, it was still possible to get an import permit
Mm.
because the import permits were only suspended.
And therefore the risk lay on the respondent to obtain those permits. Let's say we assume for a moment that factually we find it was impossible to obtain a permit. Let's just assume that. I know it's not the case. How would that change your arguments? Would you in that case accept that there had been force majeure?
We would not accept that there was force majeure because we maintain the position that respondents' clause 5.1 obligation to obtain all import permits was an absolute requirement.
Even in the
Because-
face of impossibility. I think that's where we both have
Yes.
difficulty with the interpretation. We follow you all the way to the edge of that cliff, but beyond that, if I can accept up to the point where you say, okay, if the permits were still theoretically possible but very, very difficult to get, it'd still be a risk. But I don't think they would have at any point of time reasonably accepted that they would be able to get permits when it was legally impossible to do so. So if we assume for a moment that there was legal impossibility in getting the permit, how would that change your case?
Madam President Arbitrator, if we assume that to be the case, we will accept that there would be force majeure. However, that is not on the present facts. Thank you.
Thank you.
Members of the tribunal, I just have one point to make in my rebuttals. My learned friend earlier argued that the claimant considered the respondent's words on the 10th of February to be a serious and final refusal to perform, but yet they had considered earlier that the claimant avoided the agreement on the 27th, on the 1st of March, apologies. And the email that they're referring to, which is the claimant's CEO email to respondent, clearly demonstrates that it had considered respondent's 27 February declaration that it could not perform to be the event which is the
I'm sorry,
Sorry.
getting lost. Are you trying to say that the respondent had never tried to avoid the contract? Or are you trying to say that, the respondent, whatever words the respondent had said are irrelevant because claimant took a unilateral approach to terminating the contract? And where are you going with this?
apologies. To clarify, our point is that the CEO's email, which considered 27 February to be the point in which the respondent committed a fundamental breach of the contract, is contrary to their submission that serious and final refusal was evinced by respondent on the 10th of February. Yes,
Sorry, my understanding for you is saying is that they argue I can resell the goods anytime after a serious refusal. And they said a serious refusal happened on 10th February, but you're saying that 10th February email did not show a serious refusal. An unconditional refusal. Is that the your submission in a nutshell?
Yes, Mr. Arbitrator, that 10th February was not the date of serious and final refusal, or that claimant did not actually perceive that
Okay.
the events had been.
A, that was not the date that we actually finally refused to perform. B, we never seriously refused to perform. So which one is it? Or is there a C?
It's
Do you accept that your clients at some point of time had shown that they refused to perform? Yes or no?
our position is that if they did evince no intention to perform, that would have been on the 27th and not the 10th, as the claim that my learned friend has.
So no, they didn't, but even if they did at the earliest, that would have been on the 27th.
Yes, Madam President. Thank you.
And the implication of that, therefore, is that
That the sale to Herbal Cosmetics therefore took place before serious and final refusal, and therefore that cannot constitute a substitute transaction under Article 75. Thank you.
Members of the tribunal, I have only one point in serve rebuttal. Counsel for the respondent has mentioned that there is a discrepancy in terms of when our client interpreted a serious and final refusal to perform. We disagree. It's our position that respondent had seriously and finally refused to perform twice, once on 10 February 2024 and also on 27 February 2024. Therefore, there is no
So can you bring us
discrepancy.
to the 10th February 2024 and explain communication and explain to us why that was a serious and final refusal?
Yes, Mr. Arbitrator, if you go to page 16 of the record, if you look at paragraph 4, it stated that it would be impossible to obtain the permit within the period required to meet the delivery date. And if you look at paragraph 5, our client told respondent that we had to deliver the orchids before mid-May or to another customer, and in the later case, they will only be able to deliver at the end of the year. However, respondent in reply mentioned that they will only take the information into account and only come back to them as soon as possible. Since respondent did not confirm with claimant whether they would be taking a later delivery date, even though they knew that time was of the essence under the contract, this can be interpreted as a serious and final refusal to perform of the agreement. Unless there are any further questions from the tribunal, I conclude my serve rebuttals.
Must apologize, I don't even need it. Just give me a moment. Please get it.
You want to start first? Alright, okay.
Do you want me to give general and then anything you have for them individually, or is it just generally?
As you wish.
I'll read some general remarks first. So the first is that I think some of your arguments are very, as in it's a natural tendency that you use, the arguments are difficult to understand. So like a lot of my questions were just clarificatory and trying to figure out what you're actually arguing. And I think so part of it is because you have been studying a problem for a long time, so you're familiar with all the facts. But you need to ask yourself, someone hearing this for the first time, maybe only skim the problem on the day itself. Based on what you are saying, do I actually understand the argument? And I think there are a lot of parts that assume too much background knowledge or are stated in very complex ways, very long sentences that makes it very difficult for me to understand. Not even getting to the part about whether I'm convinced, but whether I understand what you're trying to convince me.
You realize I had stopped after the jurisdiction people to ask, is there anything you've changed? One of the things you want to think about from the time the first person starts speaking is what is the level of familiarity that the bench has with the problem. And also, can they follow long sentences, because you'll see many non-native speakers where you're going as well, right? So if you realize that we were asking a lot of factual clarification type questions, then one small amendment you might want to start inserting is a bit more background information. Don't go to town with it, not like 10 minutes of background information, but possibly a bit more leading. Here's the page, this is it. Or factually what we're told is on this date this happened, on this date happened, that is why I'm saying this. So some of these small amendments when you go are quite important to helping you have a smoother ride. And that's something you want to consider from the time the first speaker speaks. First speaker has a problem because he has to make those changes on the go. But second, third, and fourth speakers have the advantage of at least 40 minutes worth of reaction time. Make use of it. Sorry, interrupt.
Yeah, so constantly ask yourself because it's easier to start that. So the first speaker has no idea. It's easier to start from a position where you're slightly slower and leading them along, and then if it's clear that they just want to get to this particular thing or that thing, then you accelerate with them, rather than you rush ahead, then you after that have to draw back and
Yeah.
spend a lot of time
Yeah.
reorienting everything. In terms of the introductions, the introductions I think they should motivate me to rule in your favor. Okay, in my view, good introductions should motivate me to rule in your favor without explicitly stating what is the argument or the conclusion you're making. So and then any other random posturing things in my view are unnecessary. So stuff like our client was fully committed to performing the contract. It's like it sounds nice, but it's neither here nor there. There's a lot of those type of I think motherhood statements. The argument in the introductions, I think. So you sort of want to put in the facts that will frame the issues in your favor, without actually going the final step and saying the argument that I may disagree with in your introduction. So that's on the introduction. I think generally the arguments can be simpler, and one way is to think of what is the point you are making really and how to make it in the most direct way. So for example, so Evan, you had a lot of things like it's an impediment, it was not an impediment that was out of your control. But I think you can just make the point that there was a non-issuance of permits, and that was a matter within their control because they have done this, that, or that. There seems to be a lot of interruption between not just you, but generally between you state the rule, and the main point that you want to make is not really coming out. So for example, interaction I recall is Mitchell asked, there was that email that has said we are okay with the current version of the rules, provided that we agree on a modified version of the AMA protocol. Then you said, so do you agree that was a condition? Then you said, that may be a fair reading of it, but then if you look at that document or not. But actually your point is just, and indeed they did agree on a modified version of the rules, so there was an agreement on the current version. There's a lot of, need to get to the point and say the topic sentences faster. I have a bunch of other miscellaneous points we got.
Oh, what's the order and the reading?
It's been kept quite general.
Oh, general, okay. So I think at this stage, I mean, part of this coming from code perspective is at this stage we shouldn't be reading anymore. So some of us are still reading, which is too late already. It's just three more weeks, right? So it's getting a bit short on time. I think okay. So Samuel, on that point, I had asked certain questions today to try to see if you can think laterally and if you understand the case. Because if you understand the case, the answer would just have been, that was agreed in the wording already. Don't worry about it. And there are actually many parts, but it's actually such an ancillary point. It was the test that, right? And it feels like you only realize that 30 seconds to 1 minute later. Okay. Let's see. I've got a lot of points actually, but let's reserve some for later. I think in terms of, you realize this bench took you away from a lot of your arguments. So as of such, half of you, the arguments did not follow any structure at the end. Right? And then you realize Elaine was actually bringing each of you around the different arguments. And then for one or two of you, actually, especially Nicholas, especially for the merits arguments, you actually have to go back to your previous argument earlier. And I anticipate that's probably what Samuel was writing. He kept on writing various things. I don't know what he wrote. My guess was that you have fallen completely out of your structure. Your argument's not complete yet. That's my guess. Maybe I'm wrong. Right? So you have to remember where you're headed. What do you still need to argue at the end of the day? Right? Then for Nicholas, for example, it got very confusing because the FM clause once you went into the interaction between the FM clause and Article 79, the first part of the argument you started getting jumbled up between which argument you were arguing. And then Yen of course caught you out on that. I thought you said possibility is not relevant. Because you're just reciting words off of the script, right? At that juncture. Because you
Maybe I was addressing the Article 79 part of it.
correct, but at the time the argument you were specifically on was already FM. So it was just very jarring where throughout the whole throughout all of today is where are we in the argument, what's the structure, what are we even arguing? Right.
So, sorry to interrupt. On that Article 79, you wanted to fuse both the force majeure and Article 79 and then argue.
The overlapping parts.
My recommendation is not to do it because there's clearly differences in the wording.
And you're
that-
setting up yourself for a fight that you don't need.
Yeah, then you
All
get
it is
to-
for people to say,
Are they really this?
are they really same? Show me how they're same. And then you go into a 14-minute rabbit hole and nothing much.
Yeah.
And then see you goodbye.
I think the concern is that there's a risk of sounding redundant.
You know, you can layer. You can say, you know, I'm going to start with the force majeure clause, right? You can always give your opinion. I think they're different. I think they're same. But let me start with the force majeure clause, right? And then you go through it. And then when you get to 74, 75, you say, well, you know, many of the arguments that I've made there are substantially similar here because in substance they are equivalent. This word in force majeure is replicated here. So that might be an easier way rather than trying to parallel argue two things at the same time.
I think that the way, so part of it was the structure, and the other part of it is the way things are explained. So of course, so Nicholas, just now when I know what point you're making because I know what your argument is, but remember Yen has much trouble accepting just your rebuttal. I know what you're going at, but do you realize from the listener point of view it's just impossible to understand what you're trying to say? What you're trying to say is now it's not on X date they did something. What you were trying to say was they're blowing hot and cold. They already said something, but now they're changing their position. That's what you're trying to say. But did the word say it? No, right? Because you just pointed to the fact. But pointing to the fact doesn't speak for itself. In fact, you didn't even point to the fact. You made reference that there was a fact inside the bundle. So you neither asked us to look at it, and you also didn't tell us what we were supposed to gather from it. So stuff like that. Then for Evan, I feel you generally have the right points, but the way it comes out is very convoluted. So the person is not familiar with the bundle, they will just be like, what is this guy talking about? And that's happened in previous rounds for you also. Okay, that's on merits lah. Yeah, I haven't talked about it.
So I think you would have discovered from the morning round, from what I've learned in this round, that this year's MOOC is very fluid. Fluid in the sense that people can blow and blow your ordering, and fluid in the sense that, you know, there are so many ways home. Many arguments can bring you home if you succeed, and you don't have to know all of that, right? So my very first suggestion to you is don't think of it in terms of a 14-minute script that you amend along the way or going to the archive. You need many Lego blocks of script that you kind of plug and play together depending on what's going on. And I saw all of you struggle actually to some extent or another because you were still trying to go through your script. Right? So you cannot, I guess, at this point of your career, you wouldn't go in and add it. But it would go a lot easier if you start having micro sound bites that you rearrange rather than this is how it's going to be. Right? So you've got argument 1, argument 2. But even within argument 1 and argument 2, you have points 1, 2, 3. You should be prepared to resequence, take out, delete, /n as you go along. Right? And that goes to the second point, which is what do you actually need to win? Right? So Samuel was the first horse out of the gate, and you were trying very hard to argue around the 2016 and the 2015 rules, and you spent a lot of time there, right? Do you really need to do that? To some extent, yes, because we kind of screwed the sequence and kind of about the first issue, right? And so I think you perhaps felt a little bit boxed in there. But there was absolutely nothing that would prevent you, if you think the first argument wasn't going so good, to say, well, you know, even if the 20 or if the other version of the rules applied, we still would be able to succeed. And a brief outline of my reasoning in advance of what respondents going to say is 1, 2, 3, and then go back to your 20, 16, 15, and plug in. There's also nothing to stop you from deciding that you made a bad call on the damn 7 minutes and you want to eject button, right? And say, I finished a little bit earlier than I anticipated and credit my 10 puts my second argument.
Remember, I give you the lifeline some more. I even said you can use the 14 minutes as long as the total is 14. You're like, no, I'm going to stick to the 7. I'm like, what? Okay lah.
Whining
Yeah, I was like,
away.
okay lah, sure.
You must know when to
Yeah.
stop, lah. Okay?
Don't, I was like, okay. Yeah.
Yeah, I think you must like get a sense of like sometimes we are trying to hint to certain things. Like the travel early on said, so would it be okay if we went this? Then like I think 2 or 3 times we wanted to insist that this is our preference. But then like I think in the grand scheme of things, it doesn't actually prejudice you that much because I presume you would have prepared to go both first and second. Yeah, so
So you heard him already, right? And you heard our questions. So now that you've had some time to cool down and think about it, in your repertoire of tricks, what do you think you could have most convincingly said to us on the 2025 and 2016 arguments?
There's no assignment
Hmm?
because there's no assignment.
I don't care what they were thinking previously, but it's not the same thing right now. If that's what you think, then that must come out straight away. Shouldn't take you like 5 minutes to get there. So the point of being the second person is you must respond. Okay? And the point of being the first person is give yourself enough words to escape that. Just like trying your merry-go-round of things until you find something that sticks. But there's so many avenues open to you, so don't feel like you must commit to one and then stick there and because there's less than the way. Which brings me to this next point I have around efficiency. What do you think is the strongest thing you can say to us on the 2015 and 2016 argument?
Actually, it's the whole thing.
Oh, yeah.
It's the whole thing.
What's the whole thing? That's a very strategic choice lah. Come on, what's the most
It's quite
convincing?
self-evident, right, Samuel, that none of the comments that have been given to you so far has been taken in. Because the simple truth is this: you're fixed in this box of what you want to do. You're fixed in this box of what you want them to hear. Nothing can be ditched. In fact, when you're out of time, what do? You try to test your luck. You try to go on for as long as you can without even looking at their faces. And the moment you're stuck there, there's really no conversation forward, you see, because everyone's trying to help you. The questions are trying to help you. If you have to shorten everything in your script and come up with the most important, try. It is not the easy way out, which is can't. They're equal.
You must have what are good to have points, trying my luck points, and you must have what you think are quite likely kill points, right? So what is your kill point on your 2016 and 2016 and 2015? Of course, there'll still be counter arguments that can be made, but what is your kill point?
I think maybe it's the second alternative.
Which is?
It's the one on the modification of the AMA clause. Because we would
One short sentence. My strongest point is that
my strongest point is that mediation that the rules apply, the 2016 rules apply because they were enforced when mediation commenced, which is the commencement of arbitration under the modified AMA clause. And this is stronger because it is easier to
your coach is dying
No,
here.
I think, look,
Okay, lower the intellectual bar. Start with things that people can. Maybe. Okay, 换个方式说. Okay, we start by looking at facts or arguments that people cannot quarrel with you. Because if you start there, you're less likely to be interrupted. So what is a very obvious and strong point that you could probably start with?
You are limited to 20 words.
Claimant and DG agreed during the board discussion to amend the AMA protocol, and respondents director was actually on the board. So it is easier.
You've already lost everyone. You know why? Too many steps. It needs to be at this level. If you're thinking so hard about what to squeeze in, then this exercise is failing.
Yeah.
It needs to be intuitive. You know what's the strongest point? When this word current was come up with, right, they were only thinking of one version which they had just read. That's what I mean by an intuitive point.
We still have to bridge it to the
Yes, but that's your next 5 minutes.
Of course, you have to bridge
Right.
it. No one is saying that. Thank you, members of the tribunal. My case is made.
You-
No one's asking you to stop there.
You need to at least get on the boat first, okay? If you cannot even get on the boat, you need to talk, nothing to talk about. You're all stuck at the point where you're trying to board the boat. You realize you get into a flow where, you know, the questions come and then you can start answering because you're in the realm of where you've got Q&A answered, right? That's a good flow, right? Sometimes you find you are stuck because you can't even get to that point. People are asking you all these random questions. Then you know that my point of entry is wrong and I need to think about it. So where is a good point of entry? So some very usual points of entry are, let's look at the words. And that one is actually strongly in your favor, right? The original freaking protocol, the original clause said very clearly for the time in being. We took out those words and we stuck the word current in. What do you think my intentions were? My intentions or what do you think respondents' intentions were? Respondents' intentions at that point clearly were for it to mean current, meaning today at the point when I signed. They are now saying that it means something else because I came along and talked about and took over the contract. Let me tell you why that's stupid. And then you spend the next 5 minutes explaining. But your entrance point is bad. It takes too long to get there. So you need to bring it down to the point where if your 5-year-old niece, nephew, cousin cannot understand it, it's too hard.
So today, I this part I'm a bit, because both morning and to now second session, nobody even has come close to the case we're actually running for claimant's procedure. So I found it very shocking. Like no one has even said the words that I thought in my mind. Maybe it's my fault. I thought we knew was our case.
No, but I mean, I wouldn't fall back on that, right? I wouldn't fall back on a certain formulation and then you'll just keep sticking to it. But I think, I share Elaine's views completely throughout the course of all four actually. You are not giving off the impression that you know your whole case. It is pieces that you want to deliver. This is part A. I would like to now go on to the second part of my first argument. And then people say, oh, but should you not address something else? Okay, since I've answered your question, now can I go back to the second part of my first? There is an intuitive, as Elaine said, fluidity means there must be a core to what you're arguing. Despite what Mei Xuan said, there are many parts to it that you still must go through. Yes, but what is the essence of the strength of your position? It's not coming out. And it sounds like we're just going through motion now.
Then you could go in there really quick. You actually don't need to set up, members of the tribunal. For the first argument, the difference between claimant and respondent turns primarily on the interpretation of the word current in clause 15. Clause 15 can be found on page. Are you there? Yes. As you can see, it includes the word current. Let me now bring you to the original SIAC model clause.
You assume that they knew the SIC model clause.
Right? You will see that the term SIAC in the original model clause, it explicitly referred to for the time being. This was intentionally struck out and replaced with the word current. That was respondent's intention. Now the question is whether claimant's intentions were matching as well. We say they are. you're essentially done. The rest of it is counter argument, right? And you can counter argue until the cows come home, but at least your main argument is done. If you want to start there, lah. What was that other argument that you thought was really strong? The protocol argument. So tell me in one sentence, short. Count on your hand, 10 words. What's that argument? 10 words.
Article 15 deems mediation as arbitration's commencement, which respondent knew.
You listen to yourself, is it convincing? So as an entry point, have you boarded the boat? If you can't board the boat, it's not a good argument.
I think right now we're choosing points based on, what will cause less of your fears to arise, which I fundamentally think it's something that you all need to get rid
To
of.
me, that's a good argument. You can make it, but you first of it's a premise on many things. You assume the person knows the file. You assume the person knows arbitration. You assume, your tribunal not that smart. If you happen to get one that's that smart, great for you. But not everyone will get it. So you can run it, but if you want to run it that way, then you really have to dumb it down a lot. Okay, now let's get to Bishan. So you heard the argument he was making about 2015, 2016. What's the strongest thing you can say? You already told me, right? The strongest thing you can say is, dude, I don't care what Botanic said, but that was not, we didn't understand that was what we know when we said taking over. Okay, if that's your argument, that's your argument. But it's a slightly different point I have to make for you. It's a logical point. Does that sound logical? Does that sound reasonable? So straight off the ground, you know you're going to have a problem with that, right? So you've got two choices. Either you're going to change and argue something else, or you're going to have to make it sound a lot more reasonable. Which version are you going to use?
The second. The second.
Okay, so you're going to make it sound more reasonable. How? What are you going to say?
Even if the respondent was assigned the contract, it doesn't matter because that contract doesn't exist anymore. And what exists is a 2022 contract.
You say that again? Say that again.
Even if the respondent was assigned the 2021 contract, it doesn't exist anymore because there's terminated.
Number one, firstly, I can't even make sense of your statement because if it was already terminated, how would they assign it?
Was assigned.
Let me give you examples of what might work. Okay, if you can prove it. So, yes, it's true, Botanic said whatever it said, and I'm not disputing that was our interpretation at the point in time. But when claimant took over, they told us things that made us think that they wanted a different interpretation and we agreed. Okay, right? Or Botanic said what it did, we said what we did, and at that point, that was what I meant. But when claimant took over, I clearly told them that I wanted something else. And they knew it. So that's why you cannot take Botanic's interpretation. Both sound logical, right? Both sound fair, right? Like, does